Yes, that's getting started. So we can at least get this part of the situation done. Now, what I would like to say to both the male and female individuals is that if anybody has hired a lawyer or expect a lawyer to be present, just let me know and we'll wait. Um,
I have never
and
had the opportunity to seek one. Correct. I have never had the opportunity to seek counsel since I've been locked up.
okay, so um, the lady that was speaking, when I call your name, ma'am, you can address whatever issue that you would like to address with me. Um, we have the ability for people to hire a lawyer. Mr. Bradley, sir, how are you?
I'm great, Judge. How are you today?
I'm doing well. Who are you representing, Mr. Bradley?
Miss Melton, Melton,
Okay.
Kendall. And
Okay.
I was just at the courthouse and I thought it was in person. And so I'm sitting in the car outside the courthouse. So I apologize.
No problem. Um, so what I'm gonna do, Mr. Melton,
Miss
is
Melton.
I'm sorry. I'm sorry, Mr. Bradley. I apologize, sir. I'm gonna read the script and then we'll call your client up first. So on the ladies' side, we're gonna have Miss Kendall Melton as the first person that is called. Um, so um, we will have a discussion, Mr. Bradley, about your client, and I'll listen to whatever you have to say about your client and and what your suggestion would be as it relates to bond. Okay.
Yes, sir. I can streamline it line it for you real quick. If I know you want to go through the script with everyone else, but ADA Chief Bunny Shaw, in between the time that I got here, which was earlier, till now, she agreed to a $10,000 bond, and she sent that in an email and copied me on it. Now, of course, my client doesn't have a history or anything like that. I would love a UJR, but she said that she didn't think that you all were doing those out here. My client has zero history, and this was something that involved domestic violence that she was protecting her sister. But there is a $10,000 bond that Chief ADA I said Shaw, I meant Bunny Smith, agreed to and emailed everyone a few minutes ago.
Okay. Would you do me a favor and in between the time that I read the script, it generally takes about 5 minutes. Would you forward that email to me?
Yes, sir.
Um, my email address is Brad dot Gardner Gardner at
Yes, sir.
Clayton County GA um, .gov.
Yes, sir.
Okay.
I can
Um,
hear you now.
yes, please. And so I'm gonna now read the script, and then Mr. Bradley will come to you
Yes,
after I
sir.
do that. Okay.
Second to email that. Thank you, Joe.
Thank you, sir. Um, good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I am here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I am authorized to set bail, to schedule a preliminary hearing and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court. Lastly, I need everyone to raise your right hand, please.
I cannot have handcuffs on, sir.
Oh, okay. Do you swear or affirm that any statements you make during this proceeding will be the truth and the whole truth, so help you God? And the purpose, just so you all know, the purpose of that is we make a determination as to whether, if you ask for a lawyer to be appointed, and that's the only reason that you're sworn in, is that any statements you make regarding that process needs to be as truthful as possible. So let's bring up Miss Melton. And I'm gonna see Mr. Bradley.
Yes,
Well, first, Miss Melton, I would normally speak to you directly, but since you've taken advantage of the opportunity to have a lawyer here assist you, I'm going to speak to Mr. Bradley. You need to understand that this is a public environment. So please don't make any statements that you would not want the whole world to know. Okay?
Okay.
All right. So let me see, Mr. Bradley,
I'm here, Judge.
if I got the email. Okay. See your email. Hmm. And I don't understand why she um just sent this to you and not to the court.
Well, I think she sent it to Miss Cheryl from her office so that it could go on and she can do the necessary steps to submit it to the court, Judge. But I just wanted, since like I said, streamline it for you to let you know that she did agree to it and it was coming down, I guess, the pipe there to get to your office as far as it being a total $10,000 bond.
Yeah, and I'm not if the parties agree, I'm not going to be a person that jumps into the middle of it.
I can give you the Reader's Digest version, Judge. I understand looking at it, it looks kind of, um, uh, the charges and the way they're written up. Um, if I may, Miss Melton, her sister was a victim of domestic violence. Miss Melton doesn't have any criminal history. The sister called the mother and Miss Melton over after her husband had hit her and spit on her. Miss Melton, quite frankly, said, "You got the wrong one the wrong day," and so she went to the house. She did not. She did not break into the house. She was let into the house by her nieces, and she went in. Her brother-in-law wasn't there at the time, and she went upstairs, got some of his clothes, took it outside, and burned them up. And so that's what you have here. So she didn't break into the home. She did, I mean, quite frankly, she did set the clothes on fire. It wasn't inside the house; it was outside in the backyard. She set it on fire, and then she left. And so that's what we have here. The victim, Mr. Hobbs, has been contacted, and he is only concerned, I think, with more of the fact that he wants his property replaced, and so we're trying to get that worked out.
Okay. I mean, that's fine with me, Mr. Bradley. The one change that I will make on this is have a no contact provision as it relates to Mr. Hobbs. And I did see the email where the district attorney indicated that they would want a no violent contact. But I was trying to say that I think of the best way to say it. But if I do a no violent contact, they raise holy H. If the victim is calling their office saying, why does this person has no violent contact? So
But if I may, Judge, I could say that he was contacted, and he in the email that he sent back to the DA's office, he indicated that he wasn't fearful of his safety and that he was okay with contact. Um, the only problem with no contact would mean that she, possibly, of course. Now, of course, she doesn't want any violent contact. She just said enough was enough. I think what's going to come out in the wash is the day prior to this, he had beat the sister, and this was another day, which was the very next day, and she just said enough is enough. You're not going to hit my sister again. But I get it, but I just don't want it to. I mean, if the court needs to put that in for the court pleasure, we will take that. But I think the DA's office has spoken to him, and he says he's okay with no violent. That was him saying he's okay with no violent contact.
So what's the living situation? Is this a situation where your client is gonna be in the same household?
No, Your Honor, they're not in the same household or anything like that. She just went to defend her sister, and so the no violent contact or no contact provision would be fine. In order for her to see her sister and her nieces, they would just have to come to her house or something like that. So if that's what the court deems necessary.
I will respect what has been negotiated and not step in the middle of that. Like I said before, it's just a situation where I've had circumstances where people had no criminal history, and I've read through the warrants and I don't see a problem. And all of a sudden, because someone is calling, it becomes an issue. So I won't belabor the point. I'm just gonna not place any condition on the bond, and I'll set the $2,500 bond for each case as what's been negotiated. So I won't place a condition on it. I mean,
Thank you, Judge.
okay. So there's going to be a preliminary hearing date that's going to be set for November 1st, but that date will get waived upon your client bonding out, and she'll get a new court date in the mail. Is there anything else, Mr. Bradley?
No, sir, Your Honor, not at this time.
Okay. All right, Mr. Bradley, you're free to go, sir. And Ms. Melton, you are free to go back.
Thank you, Judge.
Okay. Have a good day, sir.
You too.
Okay, so I see an interpreter from AAC Linguistics. It was my understanding, ma'am, that we did not need an interpreter today, but let me ask the deputies, do we need a Spanish interpreter?
No, sir. No. Not on the female side, no.
Okay. Do we need a Spanish interpreter on the male side?
That's correct, Your Honor. We're fine over here.
Okay. Well, ma'am, this is the first time that I've met you.
Nice
It
to meet
looks
you.
like it's gonna be an easy day. Thank you, ma'am.
You're very welcome. Have a good day, Your Honor.
You too. Mr. Joyner.
Hi, sorry, Your Honor. How are you today?
I'm doing well. We got started a little bit early, but we've only dealt with one person so far. Who are you representing?
Shakita Henry, Your Honor.
Okay. Can we bring up Miss Henry? Miss Henry, as I stated to the other person, I would normally speak to you directly, but since you've taken advantage of the opportunity to hire a lawyer, I will speak to your lawyer. But you have to be forewarned and understand that any statements you make here are not privileged or private. So don't say anything you would not want the whole world to know. Okay, ma'am?
Yes, sir.
Mr. Joyner, Ms. Henry is charged with an offense that I cannot set bond for at this stage. Her preliminary hearing date is going to be set for November 1st at 8:30 in the morning, courtroom 201. We're currently doing these hearings by Zoom. So that will probably be by Zoom at that time also. She's going to have a bond hearing date set for November 5th at 8:30 in the morning, also in courtroom 201, but it's most likely going to be by Zoom. Is there anything you want me to know about your client?
Not at this point, Your Honor. I do know and respect the fact that sitting as magistrate for this appearance, that you can't set a bond for that. And not that you probably would on the charge like this at this point in time with a lot more information. I do want to know, I did try to email the entry. I don't know if it got in there. I will go and file it. I just want to make sure that I'm able to get those Zoom links because I was just running around trying to get the link for today.
The short answer is COVID has been running rampant through magistrate court. I've had it, my whole family's had it. Two other individuals in the office has had it. So it's kind of like we're kind of moving things in a triage situation. What I can do, if you email me your entry, I can send it to the people that are in my office who can get it filed.
Well, Judge, I have no problem. I'm just in Fayette County. I will be in Clayton County. I will file it again. I just wanted something filed for Your Honor before this morning. So I just wanted you to know that I did try to get it in. I don't know if you had received it yet, but I will get it filed, even if I have to go down there and file it.
Okay. I mean, the answer to your question is no, I did not receive it. But I did get a phone call about the link.
Okay.
And the way, just for your knowledge, the way that things are currently working, the judges are the ones who are responsible for setting up the link so that the judge can control the Zoom hearing. And today was a day that, for whatever reason, I didn't get the information until after 8, but I would normally send my Zoom links out by 7:30 in the morning.
Well, it for sure wasn't an issue, Judge. Your office or the office over there did get me the link right away once I got the phone call. So I'm 100% fine.
There is, I believe it's going to be the three judges that may handle your client's preliminary hearing are Judge George, Judge Bridgewater, and Judge Kate Johnson. And I don't have the schedule yet for November, so I can't tell you. But it'll be one of those three.
Well, I will definitely make sure I'm in contact with their office and I'll get everything filed. We'll be ready for it, Judge.
Okay. Is there anything else, Mr. Joyner?
No, Your Honor.
Miss Henry, ma'am, you are free to go back. Please stay in contact with your lawyer about your case. And I wish you luck.
Yeah, appreciate it.
Okay. Mr. Joyner, you're free to go.
Thank you, Your Honor. You have a great day.
You too.
Your Honor,
Yes, sir.
sir, can you please take Miss Bailey and Andrea because she had to go back to medical?
Okay. Miss Bailey.
Yes, sir.
Okay.
What I know,
Good morning, ma'am.
thank you.
Ma'am, you're charged with one count of criminal trespass. The bond for this offense is going to be set at $3,000. Do you believe you can post that bond?
It is a false attempt to imprison me, sir.
I'm sorry, ma'am.
I was never at the scene of the crime, sir. I was on the sidewalk almost. I was never on Taco Bell's property.
He's just telling you your charges right now.
Okay.
And I have been incarcerated ever since. And I don't need medical, sir.
Okay.
And I haven't had an
Hey, let the
attempt.
judge talk, man. Let
Hold
the judge talk.
hold on 1 second. Hold on 1 second, Miss Bailey. I'm gonna reduce your bond to $1,000.
Sir, there was no crime.
Miss Bailey, as you stand here, you're an innocent person. I cannot decide whether you're guilty or innocent at this stage. I can appoint a lawyer to represent you. I can give you court dates for the future. The purpose of appointing the lawyer is so that you can defend yourself. Okay? So you're gonna have a $1,000 bond. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir,
I'm sorry, ma'am.
are you a tato for speed?
Ma'am, do you want a lawyer? He wants to see if you qualify for a lawyer. You want a lawyer?
Of course, I would like an attorney, but I want my own voice in conjunction with that attorney's. That is erroneous to have someone try to.
Okay, Miss Bailey, we're gonna try this one more time, okay? You,
So close to the sidewalk, sir, when I was handcuffed. I was on the sidewalk.
Ma'am, he's trying to tell you something, okay? You're supposed to be listening right now so you can take what you're charged with and try to get you a lawyer.
Miss Bailey, I cannot try your case because I don't have the other side. I say this to people often. What you're telling me, you can turn to the wall and say it to the wall, because the wall will have just as much ability as I do to do something about your charges.
May I ask a point of definition?
Yes, ma'am.
How do you define the wall?
I'm sorry.
How do you define the wall?
The wall is the wall, the cinder block wall that you see around you. When you're talking to me about whether you're innocent or guilty.
So you're saying act crazy, huh? Just talk out loud to a wall that is not a person.
Miss Bailey, do you not understand what I'm saying?
I'm trying to get points of clarification, sir, so that I can truly understand what you're saying.
So, Miss Bailey, because I cannot determine whether you're guilty or innocent, when you're telling me about your innocence, it's the same as speaking to the wall, because the wall has just as much ability to do what I can do at this
If
stage.
you cannot prove today, why am I incarcerated on a bond?
Ma'am, because you've been charged.
Just because you're charged does not mean it's legitimate.
Hey, ma'am, this is, the judge is telling you your
There's no
charges,
violence here, honey.
telling you your charges and
Miss-
trying to give you a bond.
Miss Bailey, Miss Bailey, I'm gonna try this one more time, man. I believe you. You are innocent and you have been wrongly arrested and charged. I cannot do anything other than appoint a lawyer to represent you so that when you have the ability to, ma'am,
Ma'am, you gotta face the camera, man.
okay. Miss Bailey, do you want a lawyer or not?
I have already answered that. You don't recall? I did say a lawyer. So how many times do I have to say it? I'm not
Ma'am,
facetious, sir.
ma'am, you, now, let me tell you this, Miss Bailey.
If you have hostility, it is towards yourself, not me.
Miss Bailey, Miss Bailey, you did not fill out the form. You put your name on here and your date of birth.
I have never filled out any form, sir. I was not given one.
Miss Bailey, I see a form with your name written on it.
Can you use that as
Were
an
you,
exhibit?
ma'am, were you born in 1967?
February the 3rd, 1967.
So who put that on the form? Are you telling me one of the deputies did it?
It's not in my handwriting.
Okay, well, ma'am, look. I'm trying, Miss Hard. I'm trying hard with you, Miss Bailey. You're fighting somebody.
I'm not
That's-
fighting anyone. How is my posture, sir? Please, please don't define me by your own understanding.
Miss Bailey, if this isn't fighting, I don't know what you define it as.
Please define fighting from your perspective, please.
You are not answering my questions, and you
And what
are
question is that?
taking. See, yeah, that's fighting. That's fighting right there. That's
Please,
fighting right there.
please.
Miss Bailey. Okay, let me tell you this. I have the ability to send you back. Okay, and I'm not trying to do that. I really am not.
Is it
But if you're
going
going to keep fighting me, you're going back. We can do this again tomorrow if you want to do it tomorrow. It's up to you. I am not, ma'am. I have no ill will towards you.
He's trying to tell you what you're charged with, that's all, and try to give me a bond, okay, that's all. Let him do that today, so you don't have to do it tomorrow, okay? That's all he's trying to do.
Miss Bailey, are you currently working?
I'm retired. I retired.
I'm gonna find that you qualify. I'm going to appoint a lawyer to represent you. You're gonna have a bond hearing date set for, I'm sorry, a preliminary hearing date set for November 2nd in courtroom 201 at 8:30 in the morning. Ma'am, you're free to go back.
Oh, right.
I'm sorry. Ma'am, you're free to go back.
Hey, yeah, come on, man.
Thank you, sir, for being honorable.
Come on, take that.
Miss Anderson,
I got you.
Anderson,
Okay. All right. So are you Miss Anderson?
Yes, sir.
Okay, ma'am, you've been charged with one count of terroristic threats or acts. The bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir. Yes.
There's going to be a stay away provision on the bond to stay away from Keith Wright. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you get a new court date in the mail. Do you have, well, before I ask that question, would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay, ma'am, I'm going to find that you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back. We have Miss Bennett next.
yes, sir.
Yes, sir.
Okay, ma'am, you've been charged with one count of obstructing an officer. I'm gonna set the bond at $2,000. Do you believe you can post that bond?
Yes, sir.
And you indicated that you do not need an appointed lawyer. Is it your intent to hire your own lawyer?
I have a counsel.
Okay. Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions of me, ma'am?
Not at this time.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Gibson. Give me 1 second, ma'am. I'm sorry. Ma'am, you're charged with one count of simple assault, family violence, and one count of obstructing or hindering an emergency telephone call. There's going to be a $3,000 bond set on the simple assault charge. There's going to be a $2,000 bond set on the obstructing or hindering the emergency telephone call. So it's going to be a total bond set at $5,000. Do you believe you can post that bond? I'm sorry, ma'am. Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. The date will get waived when you're bonding out, and you'll get a new court date in the mail. And I'm sorry, I was pausing because I don't, I'm not going to put a stay away provision on the bond. So do you have any questions of me?
No, sir.
I'm sorry.
No, sir.
Okay, ma'am, you're free to go back. Miss Gordon? All right, ma'am, you've been charged with one count of criminal trespass. The bond is going to be set at $3,000. Do you believe you can post that bond?
Yes.
There's going to be a stairway provision on this bond, ma'am. The stairway from a Mr. Matthew Lauren. Do you understand that?
Yes, sir.
Okay. Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir, I don't.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Jones,
Good morning.
good morning, ma'am. You're charged with 1 count of family violence battery. And I'm not gonna mention the second offense, but do you understand the second offense that you're charged with?
Yes.
Okay, there's gonna be a $5,000 bond on the battery charge. And there's going to be a $5,000 bond on the second charge. So that's gonna be a total bond of $10,000. Do you believe you can post that bond?
I cannot.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. I would encourage you, though, ma'am, to contact bonding companies that are authorized to write bonds here in Clayton County, because that's their business model, is helping people to get out of jail, and they will work with you. Your preliminary hearing date is going to be set for, hold on one second. It's going to be set for November 1st at 8:30 in the morning, courtroom 201. Do you have any questions for me?
Yes, I do.
Okay.
I was informed upon my arrival here, since it's my first time ever being in jail, incarcerated, that Clayton County used to have a signature bond. Is that accurate?
That it's still the technical term is unsecured judicial release. And that still exists, but is based upon the allegations in conjunction with the person's criminal history. And so the way that it currently works, the chief magistrate judge, Keisha Wright Hill, is the person that okays an unsecured judicial release. If you wanted me to make that request, I will have to continue your case over until tomorrow for her to take a look at it. And she'll make the determination. And it could be yes, it could be no. I think the allegations in your case for the second charge, I think it may be unlikely that she would grant an unsecured judicial release. So if you're asking me to make that request, knowing that she may say no, I will continue your case over until tomorrow, and I will speak to her this evening, and she'll tell me her decision.
May I speak?
Yes, ma'am.
With the continuance of my case for tomorrow, on the slightest chance that she may say yes, would I have to remain in jail until that time?
Yes, ma'am.
First time offender, never been in jail before, never been incarcerated, never been in trouble legally, except for speeding. Disobedient child, doesn't matter the age. Circumstances are what they are. Please advise best course of action.
So, I've said,
Retired educator and veteran. Single Black mother in Clayton County. Brown mother. First time offense. Disabled veteran. Emotional, yes.
ma'am, do you want me to speak, or you just want a monologue? I mean, we can have a conversation, or you can have a monologue, and I'll let you, have your monologue if that's what you want.
Dialogue, please.
So, setting a bond is something that generally you look at it as a way of how do I try to be fair. So the $5,000 bond for the battery, family violence, I set that bond for everybody, because I believe that it's fair to treat everybody the same. The second charge is a felony offense, and I've set the bond at an amount that I believe is fair. When you tell me that you are, a person that has not ever been arrested before, if this is the first time that you're arrested for murder, if this is the first time that you're arrested for trafficking marijuana, which happens a lot because we have the airport here and people fly in, I'm not allowed to set bond. I cannot. That is just, there are certain offenses where it's like, I, as a magistrate judge, cannot set bond. Doesn't matter if you're a single Black woman living in Clayton County and you're doing the best you can. Certain offenses you're going to set. The current charges, I don't believe the bonds that I've set to be unreasonable. If you want to have a discussion about that, we can. But to say that, well, look, I got charged with this, if I beat my wife up, and I'm like, I've never been to jail before. Yeah, I beat my wife up, but shouldn't I get an OR bond? Because it's the first time that I've beaten her up. It doesn't work that way.
Understand.
So if you want to have a discussion about the bond amount, we can, but I'm telling you, the allegations, you're here presumed to be innocent, but at the same time, as a judge, when I set a bond, I have to be concerned about the public well-being and the public safety. And so that's what I look at.
I understand.
Okay,
My only situation with that is, I am currently unemployed. And $10,000 bond is a big excessive. I am unemployed. I live in poverty. I have no family who I can count on for that amount. Thank you, Your Honor.
okay. All right, ma'am. You're free to go back. I don't, based upon the allegations, I don't think I'm inclined to reduce the bond amount. Let me ask you this, ma'am. Just to move things along, this is what I'll do, ma'am. And I know this may not be considered it may not be considered to be okay in your mind. I'll just to move this along, I'm gonna on the second charge, I'm gonna reduce it down to $2,500.
Thank you.
So I've appointed a lawyer. Did I tell you your court date?
November 1st.
Okay. All right, ma'am. You're free to go back.
Thank you.
You are Miss Murphy.
No, sir.
I'm sorry, ma'am.
No, sir. I'm
What's your name, ma'am?
Rayford.
Say that one more time. Rayford. You said Rayford.
Yes, sir.
Okay. Miss Rayford. Well, let me ask you this. Deputy, is Miss Murphy, is she OTB?
No, Your Honor, she's infirmary right now.
Oh, okay. I saw the email. I'm sorry. So I'll do a continuance order for her. Miss Rayford, ma'am, you're charged with 1 count of simple battery. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
You're going to have a preliminary hearing date set for November 2nd at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on the bond, and the name is kind of hard to see, but it's looks like it's Ashley Ray.
Ashley Peon.
I'm sorry.
Ashley Peon.
Okay. So do you understand that, ma'am?
Yes, sir.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay.
And I do have a question, sir.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. And you said something, but I didn't hear it.
Oh, yes, that's I had a question.
Yes, ma'am.
Is there a way that the letter that's gonna be sent in the mail can go to a different address?
So when you bond out and you're going through the process of bonding out, make sure you give, if you have a new address, you give that address to the sheriff's office personnel. And upon bonding out, your case for that court date, it will get changed. And so you'll have probably like a few weeks where you can put in a change of address form with the state court of Clayton County. And so that way, if you do those two things, you will make certain that you won't miss the court date.
Yes, sir.
And you can also go to the Clayton County, it's claytoncountyga.gov, and there's a outward facing interface on the website where it says court record search. So you can just check that address, check that website also to make certain that you don't miss any court dates.
Yes, sir.
Okay, anything else, ma'am?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
Are you Miss White? Miss White, ma'am, you've been charged with 1 count of simple battery. Bond is going to be set at $3,000. Do you believe you can post that bond?
What you say?
I'm sorry. I can't understand you, ma'am. Could you say that one more time?
She said she didn't hear you, Your Honor.
Okay. Her bond is, she's been charged with 1 count of simple battery. Her bond is going to be set at $3,000. Does she believe she can make, do you believe you can post that bond, ma'am?
No, sir.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for November 2nd at 8:30 in the morning, courtroom 203. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on your bond to stay away from a Niger Jefferson. Do you understand that?
I can hear you, sir. Can you say it one more time, please?
There's going to be a stay away provision on your bond to stay away from a Niger Jefferson. Okay, do you understand that?
Yes, sir.
Do you have any questions of me, ma'am?
Yes, sir. So, you're not gonna be able to let me go?
I'm sorry, I didn't understand you.
You're not gonna be able to let me go, and you're not gonna be able to let me go home. And when I get some money, when I go back to work, when I go back to work and get paid Friday, I can just pay out. Cause I go with money and I get paid Fridays. So I'm trying to see, can I go home today? And when I get paid, I can bring out that money back. Cause I don't got no people up in my people in South Carolina. And I be helping my mama pay bills and rent. But I do work at Emory University College in Decatur.
Okay, ma'am, what you're gonna need to do, I think there are like 4 or 5 bonding companies. You're gonna need to contact them, and you can make arrangements with them to make certain that you can get out today, but you're gonna have to take those steps, okay?
So you said call the bonding people?
Yes, ma'am. And have a conversation with them. Your name, your charges, your bond amount, and see what they're willing to do to help you get out.
Okay.
Okay? All right, ma'am. You are free to go back.
Thank you.
That's it, Your Honor.
Okay, thank you. I apologize. I'm dragging today. I
Yes,
think I'm
sir.
going to be dragging the whole week, so
Okay.
I'll apologize in advance for tomorrow and Friday.
Sir,
Yes, ma'am.
You gave me the name of the, accurate name of the signature bond. Can you repeat what that was?
Are you talking about the unsecured judicial release?
Yes, please.
you wanted the correct way to say it, sir.
Oh, okay. The short way they call it UJR bonds. But there's something that at least in Clayton County, because we don't have like a somewhere like Fulton County, they have a probation office that people that you have to report to and that kind of stuff, and that's not really built out here in Clayton County. So if you were to be placed on a UJR bond, you would basically be out on your own. And so that's why the chief looks at these and very carefully. And so when you're in a situation where you're charged with actually an allegation of violence, it becomes a it just becomes a thing that becomes unwieldy. But I'm sorry, go ahead, ma'am.
It becomes on what?
Unwieldy, because the primary things, at least from the conversations that I've had when we've talked about these issues, if you're like a college student and you have, a marijuana joint or something, that's like, okay, all right. But if you're a person that's charged with committing a crime of violence, that's where the public safety aspect comes into play. And so as judges, it's not, even though you're presumed innocent, I have to also look at the case as, what if this person committed the offense? And am I letting this person, back out on the public where the person is just going to do whatever they want to do? So crimes where there are allegations of violence become pretty difficult to do a UJR bond.
Question.
Yes, ma'am.
The stay away protective orders, can that be implemented in my situation?
It can.
You said it can?
Yes, ma'am. It can. The problem is that the police are called on the back end of a crime of violence. So letting you out on a UJR bond and you go and commit an act of violence, that's not protecting the public. In the situations, especially when you're talking about allegations of acts of violence, is that the bond becomes a situation where the person has skin in the game, so to speak. That it's like, hey, I could go and do whatever I want to do, but I'm gonna lose this money that I've put down to secure my release, and I'm going to be sitting in jail. So it acts as sort of a thing where if there's an allegation of violence, that a person may think twice before they get themselves caught up in another situation.
I understand, Your Honor.
You gotta go now.
So are we done on the lady side? Okay. All right. Well, thank you for your assistance. Let's switch over to the male side.
Yes, sir.
Mr. Acevedo.
Good morning, Your Honor.
Good morning, sir. You're charged with one count of speeding, one count of improper or erratic lane change, and one count of reckless driving. There's going to be a $1,000 bond. I'm sorry. Hold on. Do we back on the lady side? Do we need?
No, sir. We told.
Okay. All right. There's going to be a $1,000 bond on the speeding charge, a $1,000 bond on the improper or erratic lane change, and a $2,000 bond on reckless driving. So that's going to be a total bond of $4,000. Do you believe you can post that bond, sir?
Yes, Your Honor.
There's going to be a preliminary hearing date set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, Your Honor.
I'm sorry?
No, Your Honor.
Okay. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
All right, thank you.
Mr. Brown. Well, I'm sorry. Let's save Mr. Brown for the end.
Mr. Davis.
Davis.
Just 1 second, Your Honor.
No problem.
No, all right, ready,
Mr. Davis.
Yes, sir.
Sir, you're charged with one count of driving a vehicle with an expired tag, one count of failing to register your vehicle within 7 days. And then you're charged with 2 simple possession counts of possession of Oxycontin and Xanax. So you're going to have a $500 bond set on a tag charge, $500 bond set on the unregistered vehicle charge, and $3,000 each on the possession of Oxycontin and the possession of Xanax. So that's going to be a total bond of $7,000. Do you believe you can post that bond, sir?
Sir, honestly, probably not. I'm actually my grandmother's caregiver. She's in hospice at the house, and my mother has cirrhosis of the liver as well. And I'm trying to figure out how I'm going to work this. 'Cause I don't have anybody there to be able to take care of my grandma while she's in hospice and stuff. And you know, I kind of come from I guess you could say a poor family. And, I don't know if I'll be able to make that bond right off, or I don't know if I'll be able to make the bond at all.
Mr. Davis, that is not a compelling argument to me.
I understand, I'm just letting you know. I mean,
I mean, if your grandmother has these issues, you know, you shouldn't be in a position of having these drugs in the car.
yeah, correct.
So I'm going to set a preliminary hearing date for November 1st. Courtroom 201, 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, Mr. Davis. I'm going to appoint a lawyer to represent you. But if you have those issues and those situations going on, you can't afford to be out here getting arrested.
Yeah, I mean, the last thing I hate to see is something happen to someone while I'm locked up.
There's, I have a simple response to that, is that you knew that those conditions existed before yesterday, and you chose to act in a manner that would not help you and help those that you're trying to help. So I can't be responsible for that. And I know it sounds kind of cold or heartless, but it's like, hey, we all got bills to pay. We all got to do the things we have to do. And when you start doing things that take you away from your purpose or what you're supposed to be doing, you can't ask somebody else to care if you don't care.
Yeah.
Okay.
Yeah, makes sense.
All right, sir. You're free to go back.
Mr. Everett. No, that's not.
Mr. Everett, do you know what you're being charged with, sir?
I do.
I'm sorry.
I do.
Okay. Bond is going to be denied at this stage. I'm going to set a preliminary hearing date for November 1st, and I'm going to set a bond hearing date for November 5th. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back, Mr. Everett.
Feliciano. Keep your mask on, please.
Mr. Feliciano, sir, you're charged with home invasion, first degree, 2 counts. Bond is going to be denied at this point on both of these offenses. I'm going to set you a preliminary hearing date for November 1st at 8:30 in the morning. I'm going to set a bond hearing date for November 5th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of lawyer? You didn't fill the form out, so you
Can I make a quick statement?
yes, sir.
I'd just like to ask for your leniency here, and give you some context without going too specific with the details of the case. I believe this was a misunderstanding. and the case will play out in court to show that. As far as the bond, I would ask that you reconsider due to the fact that I was actually involved in a car accident, so to speak, where I was lost at the time, and
Okay.
I lost my GPS, I lost my way, I didn't know where I was, and then finally lost my phone access. So I was really wandering around looking for, not wandering, but I was really looking for help. And it, I'm the only one that was injured in this incident.
Okay.
I received multiple gunshot wounds to both arms. I've been in the hospital for 2 days. And I really do strongly believe that, of course, the court case will play out to show that this was really just a misunderstanding. I don't have any violent history. So what I'm asking is that you can find it in your heart to just allow me to post bond so that my family can take care of me, and then I can be prepared to hire my own lawyer and work on the case.
Okay, give me 1 second. Give me 1 second. I'm taking it all in. I don't want you to say more than you need to say. So the charge that you're charged with is one of the offenses that I cannot set bond at this stage. And it is the code section is OCGA 17-6-1, and the subsection is A5. So it says following offenses are available only before a judge of the Superior Court. And A5.1 is home invasion in the first degree. So that's something that prevents me at this point to set a bond. However, the district attorney's office can consent to a bond. So they can agree to a bond for you tomorrow. And you're right, you don't have a criminal history. So it was one of these situations where if I could, I would, but I can't. But because you don't have a criminal history, you may want to talk to your lawyer about, hey, can you contact the district attorney's office? Because most likely, and I can't speak for them, but most likely they may agree.
Okay, so I would have to contact the district attorney's office and ask for a consent to a bond.
Your lawyer.
My
Your
lawyer.
lawyer would. Yes. So, I mean, it's a consent bond is something that the district attorney's office, they would be in the mix, and they would look at the case and make a determination. Okay.
Okay.
Any other questions for me, sir?
Any information you can give me as far as district attorney office number, contact information that I can use?
Well, I mean, it's the district attorney. I don't know the number, but Google search or even going on Clayton County ga.gov would allow you to have access to that information.
Okay, so there's absolutely nothing you can do right now for me to postpone, even if it was a premium or anything like that, as of right now?
Right. I would, so just to give you thumbnail sketch of how it works. Magistrate court judge doing first appearance, there are some constraints that are placed upon us because they don't want, and basically it's a political thing, but they don't want, person getting arrested and judge sets them a bond and district attorney's office says, no, we don't want that person released. So they have, through their ability to lobby the legislature, there are certain crimes that we just cannot set a bond on at this stage. But it doesn't mean that it cannot change. Like I said, today is Wednesday. If if your lawyer is able to contact the district attorney's office and get the information to them that they need, you could be out before Friday. Okay.
Okay.
Any other questions, sir?
No.
Okay, you're free to go back. Mr. Futrell? Is he still here or is he OTB?
He's coming on, he's right here.
Okay. Mr. Futrell, sir, you're charged with 1 count of possession of marijuana less than an ounce. This is the situation where the bond is set by schedule, which means it's automatically set. So it's $1,500, but there's going to be a little bit more added on. Sheriff's Department is required to add fees by law. Do you believe you can post this bond?
So,
I'm sorry.
what type of fees?
I did not hear you, sir. I'm sorry.
What type of fees? Like, how much?
1,500 is the bond that's set by schedule. I think with the fees that are added on, it may be like 1,800 or something like that. So do you believe you can post that bond?
That's a bud. By all means.
Did you say yes? Oh, okay. Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Nah,
Okay. Do you have any questions of me?
I'm gonna go. Next person?
He said no, Your Honor.
Okay, I was going to say, I'm just looking for a simple yes or no. I could not understand what he was saying. Thank you. Mr. Green.
He's coming up, Your Honor.
Okay. Mr. Green, sir, you're charged with 1 count of violation of Georgia Controlled Substance Act, possession of a controlled substance. Bond is going to be set at $3,000. Do you believe you can post that bond?
Sir.
Your preliminary hearing date is going to be set for November 1st, because this is a felony offense, at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I probably get a lawyer. I don't know what's going on yet. I've been talking to my folks. They're supposed to give me a lawyer. I don't know what's going on right now.
Okay, so the answer to my question is no.
Yeah, no, right now.
Okay, thank you, Mr. Green. Do you have any questions of me?
That's it.
Okay, sir, you're free to go back.
Can I ask you one question, sir?
Yes, yes, sir.
I looked on the thing they arrested me for was really empty.
I'm sorry.
No, never mind.
Oh, okay.
I appreciate it.
Okay, sir, you're free to go back. Is it Haynes Turner?
It's coming up, Your Honor.
Okay. Mr. Haynes Turner, sir, you're charged with 1 count of fleeing from a police officer, 1 count of a red light violation, and 1 count of concealing the identity of vehicle through a tag. It's going to be a $2,000 bond for the fleeing from a police officer, a $500 bond for the red light violation, and a $500 bond for the tag violation. That's a total bond of $3,000. Do you believe you can post that bond, sir?
Yes, sir.
Okay. Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Malone.
How you doing, brother?
Good morning, Mr. Or I guess now it's afternoon, Mr. Malone. Sir, you're charged with 1 count of speeding. Bond is going to be set at $1,000. 1 count of obstructing or hindering a law enforcement officer. Bond is going to be set at $2,000. 1 count of laying drags. Bond is set at $500. And 1 count of cruelty to children in the 3rd degree, which is a misdemeanor offense, and the bond is going to be set at $2,000. So that's going to be a total bond of, let's see. $10,500. You believe you can post that bond, sir?
Yes, Your Honor.
Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. I'm sorry. All right, you do qualify, Mr. Malone. I'm going to appoint a lawyer to represent you. I'm not going to place a stay away provision on this. What's your living arrangement?
I live with my mom right now, but at the time I was living with my child's mother. I don't live with them. I live with my mom now.
Okay. Okay, I'm not going to place a stay away provision on this, but you should know that if there are circumstances where you are coming back around, there could be a temporary protective order filed. So just govern yourself accordingly, okay, sir?
Yes, sir.
Okay, you're free to go back. Mr.
Morales.
Mr. Morales, sir, you're charged with 1 count of driving a vehicle with no license and 1 count of driving a vehicle with no insurance. Both of these bonds are set by schedule, which means they're automatically set. They're both set at $1,000 each. So that's going to be a total bond of $2,000. Do you believe you can post that bond, sir?
Yes.
Okay. Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? No? Do you want a lawyer, Mr. Morales? Okay. Do you have any questions of me? Okay, you're free to go back, sir. Mr. Myers.
Good afternoon.
Good afternoon, sir. You're charged with one count of driving under the influence of alcohol. To the extent that you're a less safe driver, bond is going to be set at $5,000 for that. One count of improper lane change, bond is going to be set at $500. One count of driving a vehicle with an expired or invalid tag, bond is going to be set at $500. Driving a vehicle with no insurance, bond is going to be set at $1,000. And there are 2 counts of serious injury by motor vehicle. And these are both felony offenses. So bond is going to be set at $5,000 a piece for each of those offenses. So you're going to have a total bond set at, let's see, 15, 16, $17,000. Do you believe you can post that bond?
No, sir.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
You said no?
No.
Okay. Your preliminary hearing date is going to be set for November 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Do you have any questions of me?
No.
Okay, you're free to go back, sir. Mr. Is it Myrick? Are you Mr. Myrick?
How are you?
I'm sorry, sir.
Good. How are you?
I'm doing well. Sir, you're charged with one count of reckless driving. This is a misdemeanor offense. Bond is going to be set at $1,500. Do you believe you can post that bond?
Yes, sir.
You're going to have a preliminary hearing date set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back. Mr. Perry.
How you doing?
I'm doing well. Mr. Perry, you're charged with one count of battery. I'm not gonna state the rest of it, the allegation, but your bond is gonna be set at $5,000. Do you believe you can post that bond?
Yeah.
Your preliminary hearing date is gonna be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on your bond, a stay away from looks like Kyra Clayton, Korea.
Yeah.
Okay. Do you understand that, sir?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, sir, you're free to go back. Are you Mr. Is it Rangel? Okay, do you know what you've been charged with, sir?
Yes.
Okay. Bond is going to be denied at this point on these charges. I'm going to set a preliminary hearing date for November 1st at 8:30 in the morning in courtroom 201. I'm going to set a bond hearing date for November 5th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, sir. You're free to go back. Are you Mr. Rice? Okay, sir. You've been charged with one count of trafficking marijuana and one count of obstruction of an officer. This trafficking charge, any allegation of a weight more than 10 pounds, I'm not allowed to set bond at this hearing. So bond is going to be denied on the trafficking charge. I'm going to set a $2,000 bond on the marijuana charge. You're going to have a preliminary hearing date set for November 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for November 5th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer, or you're going to hire your own lawyer?
I couldn't even hear you, sir.
I'm sorry?
I couldn't really hear you. It was going in and out.
Oh,
And I didn't want to interrupt you, so I was gonna let you finish before I told you.
no, that's fine, sir. So I cannot set bond on the trafficking marijuana.
Okay.
I have set bond on the obstruction of an officer at $2,000. There's going to be a preliminary hearing date set for November 1st at 8:30 in the morning. And there's going to be a bond hearing date set for November 5th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer, or you're going to hire your own lawyer?
Yes, I would like to see if I qualify until I get other notifications back.
Okay. It says that you are employed, but how much do you make per hour?
Probably like 12, 13.
Okay. You do qualify, sir. I am going to appoint a lawyer to represent you. Do you have any questions of me?
There's no way I can push my bail hearing up, like if I contact my lawyer.
So,
Because they gave me a court date when they arrested me, but I don't know what court date that is.
yeah, I was gonna say that the short answer to your question is that I cannot set a bond for you
Oh, no.
today. No. Listen. But your lawyer can get a consent bond for you tomorrow.
Okay.
So it'll have to come through the district attorney's office.
Okay.
So that's why I was trying to answer your question as completely as I can. To get these dates pushed up, that's not going to be able to happen. The COVID stuff has pushed everything out.
No,
So
only
you,
reason I asked was because when they arrested me yesterday, they gave me a court date that was like on the 23rd, and I didn't know what that was.
to be honest with you, I don't know because I don't have
that.
that information. What used to occur before the whole COVID stuff is you'd be in court within 10 days maximum of your arrest. But because of all of the COVID related stuff, it's pushed these dates out. So they, the officers would, in the old scenario, they would pick a date when they would arrest someone. They would say, I'm available on this date, that date. And because everything was in regular order, everything was moving a lot faster, you know, it worked a lot differently than it does now.
Okay.
Okay.
Yes, sir.
So talk to your lawyer, try to now I've appointed a lawyer, and I don't know when that lawyer will come and see you. And, you know, I tell people I don't work for the public defender's office, so I don't have their schedule. If you're trying to get out, it may behoove you to hire a lawyer so that you can have a more direct line of communication.
Okay, I was just waiting to see a judge before I made any moves. That's all. And you answered a lot of my questions.
Okay. All right, sir. You're free to go back. Mr. Richardson.
We asked her, he can be continued. I guess she was.
Okay. Okay. Nope, no problem. I will I'll do a continuance order. Mr. Is it Walker?
Good afternoon, Your Honor.
Good afternoon, Mr. Walker. Hold on, I'm gotta make a note. Sir, you're charged with one count of financial transaction card fraud. This is a felony offense. Bond is going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
You're going to have a preliminary hearing date set for November 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Walker. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, I don't. No.
Okay. You're free to go back, sir. Mr. Weldon.
What's up? He's coming up, Your Honor.
Okay. Give me one. Oh, go ahead.
Yes, sir.
Mr. Weldon, sir, you're charged with one count of battery, family violence. Bond is going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
I'm sorry, sir.
Yes, sir.
You're gonna have a preliminary hearing date set for November 2nd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on the bond, to stay away from a Shakita Gibbs. Do you understand that, sir?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify? Well, let me ask you this. Are you currently working?
What's on sheet SSI?
Okay. About how much do you make per hour?
On my SSI, I think they send me like 520 something dollars, something like that.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, just what you said my bond was?
$5,000.
Okay.
Any other questions?
No, sir.
Okay, free to go back. Mr. Wheeler.
Yes, sir.
Mr. Wheeler, sir, you've been charged with 1 count of simple assault and 1 count of aggravated assault. I'm going to set a $3,000 bond on the simple assault and a $10,000 bond on the aggravated assault for a total bond of $13,000. Do you believe you can post that bond?
No.
Okay. There's going to be a stay away provision on this bond to stay away from a Marika Horton. Do you understand that?
Yeah.
Your preliminary hearing date is going to be set for November 1st at 8:30 in the morning, courtroom 201, because the aggravated assault is a felony offense. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify. Mr. Wheeler, I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, no.
Okay, all right, sir. You're free to go back.
Okay, thank you.
You're welcome. Mr. Whipple?
Good afternoon, Your Honor.
Good afternoon. Mr. Whipple, you've been charged with 1 count of possession with intent to distribute a controlled substance, 1 count of says manufacturing a controlled substance, and 1 count of use or possession of drug-related objects. So you're going to have a $5,000 bond on the possession with intent to distribute, and a $10,000 bond on the manufacture with intent to sell charge, and a $1,500 bond on the use of possession of drug-related objects. So you're going to have a total bond of $16,500. Do you believe you can post that bond, sir?
Yes, sir.
Okay. Your preliminary hearing date is going to be set for November 1st at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? You didn't fill it out, so you have your own lawyer?
Yes, sir.
Okay. Do you have any questions of me, Mr. Whipple?
No, sir.
Okay, sir, you're free to go back. So we got Mr. Brown.
No.
Mr. Brown, good afternoon, sir. you are here on what's called a fugitive from justice warrant. Has anybody spoken to you about this?
Yes,
Um,
but I understand what he was saying yesterday. He said like I got 30 days or something, I got up to 30 days or something.
yes, sir. So, do you have any questions of me about the process?
Yes, it's like, what I'm being charged with, like how long I'm gonna be here.
Okay, so the allegation is that there's a warrant for your arrest out of looks like it says Detroit. And I'm not going to discuss what the allegation is, but it says that there's a warrant out of Detroit. I mean, and I will discuss it if that's what, if you want me to.
No, I know a little bit of it.
Okay, so if you sign a waiver today, the clock begins to run for Detroit, for the people in Detroit to come down and get you. And if they don't get you within the time period, you could be released, but it will not mean that the warrant goes away.
Right.
If you,
what if I don't sign it? That's a good thing if I do sign it.
well, I'll explain it this way. If you say, if you demand the extradition here, then sometime within the next 90 days, there will be a hearing, and primarily the thing that will be determined at that hearing is whether you are Ragland Delano Brown and whether the warrant is valid, meaning that you're being charged with an offense that, if true, could be a violation of the law. So if you say, look, I want a hearing, so sometime between now and the next 90 days, you'll have that hearing. And the judge will make that determination. And then the clock will start to run for them to have to come and get you. If you waive the extradition hearing, then the clock begins to run today. And I generally tell people that Clayton County has no interest in your guilt or innocence. That's not what any hearing down here will be to determine. If you want to move your situation along, then waiving the extradition hearing may be in your best interest. But in any event, whether you have the extradition hearing or whether you waive the extradition hearing, you need to start considering about having counsel represent you up in Detroit. And so I can't tell you, what to do or not to do, but at the same time, only you know what is best for you.
Yeah, I'll wait to get it started right now.
Okay. Do you, deputy, so you have the waiver forms?
It's coming down, Your Honor.
Okay. So Mr. Brown, once you sign the waiver forms, the deputies will send it over to me, and then I'll sign it and we'll be done. Okay.
Thanks a lot.
No problem. All right. Do we have anything else?
That's gonna be it for the calendar today, Your Honor.
Okay. Thank you for your patience as I struggling through this. I'm hoping not to get any more phone calls in the middle of the night, but we'll see.